You ready? The defendant moves to suppress statements made subsequent to his arrest. The court finds that there was not probable cause to arrest defendant, and therefore statements made subsequent to his arrest were suppressed. As a matter of law, probable cause is a consequence of the subject's conduct and not that of the inquiring police officer. The officer may rely to some extent on information received relating to the subject and or observations of the subject. A subject who breaks free from the grasp of one officer may be apprehended by another officer, but not arrested by the latter officer if the first did not have probable cause to arrest the subject in the first place. In other words, resistance to being apprehended by one officer does not establish probable cause to arrest by another officer. In the case at bar, the court finds that police officers who join in a police search do not have probable cause to arrest the subject if the original police officer chasing the subject was without probable cause to make such an arrest. Even though fleeing from a police officer may be ground to apprehend the subject, arresting such a person must be grounded on probable cause. Police officer Dooley of the 3rd Precinct testified that at approximately 1 a.m. in the morning he saw from the public street the defendant and another individual in an alley. As the officer walked down the alley, the other individual apprehended the officer with a closed beer bottle in his hand. At approximately the same time, the defendant purportedly dropped a bag which apparently contained a beer bottle. The defendant then ran out of the alley. It should be noted that the officer neither observed the subject drinking from the bottle, nor that the bottle was opened. Upon reaching the location where the subject dropped the bag, the officer testified that he found an open bottle in the bag. No portion of the bottle was preserved as evidence. When Officer Dooley left the alley in pursuit of the defendant, he observed another police officer grabbing onto the defendant. The defendant, however, fled and was subsequently chased by other officers who had arrived at the scene. At some point, the defendant had been caught by the pursuing police officers as he attempted to climb from one side of a fence to the other. The defendant was arrested for violating a municipal ordinance relating to the possession of an open alcoholic container in a public place with the intent to consume it. He was also charged with resisting arrest. Subsequently, statements were taken from the defendant while he was in custody. Those statements are the subject of this supplemental hearing. The first issue before the court is whether there was probable cause to arrest the defendant based on the observations of Officer Dooley. The court finds that there was not. The defendant was charged with armed robbery, possession of an open alcoholic container in public. The town's open container statute provides the following. It shall be a violation of this local law for any person to have in his possession in an open container an alcoholic beverage while in any public place for the purpose of consuming such alcoholic beverage by himself or by another person. It is a violation of the ordinance in question to consume alcohol in a public place. However, the evidence presented leads this court to conclude that if the purported unrecovered open bottle was in the possession of the defendant when observed by the police officer, the defendant was the private property and therefore was in a public place. The property on which the alley was located was private property as indicated by the signs affixed to the building next to the alley, which set forth that there was no parking because the area was private property. See Defendant's Hearing Exhibit B and E. The defense also provided evidence of private ownership of the property by producing the deed to the subject property. Accordingly, there is no basis to charge the defendant with possession of an open alcohol container in a public place. The defendant was not observed to be in possession of such container while in a public place, but rather only while he was on private property. The defendant may have committed other violations such as trespass or littering, but such was never raised, nor charged, nor testified to. $130. How's it?